Hello, I'm Ken Schwartz. I'm an attorney, and I have an office in Bethpage, New York. My firm specializes in distressed properties, foreclosures, short sales, loan modifications, and anything that goes along with it in terms of litigation. Anyway, we are here today to talk about the stages of a foreclosure action. Stages. Why do we care about the stages of a foreclosure action, evolution of a case? Because it answers a number of questions. One question it may answer is, how long do you have in the house before the foreclosure sale takes place? A lot of folks want to know that from day one. But what about if you want to find out from day 360? How much longer do you have in the house? Also, can you raise defenses? Can you seek loss mitigation, short sale, loan modification? And can you still raise defenses at all steps of the case? So these are the kinds of things that you could find out if you know the evolution of the case. So how does a foreclosure case begin? The first step would be the plaintiff or the lender would file a document called a summons and complaint, which is a description of the cause of action, in the county clerk's office where the property is located. So if the property is situated within Nassau County, then the summons and complaint gets filed in Nassau County. Now, along with that, a document called a notice of pendency or a lis pendens gets filed, and that serves as notice to the world, technically, that a foreclosure action is pending against the property. Once that's filed, the papers are then served upon the defendant or defendants. In a foreclosure case, anybody having an interest in the property must be named as a defendant. So one party would be the owner, another a borrower. They could be one of the same. The folks that signed the promissory note. There could be a subordinate interest, a judgment creditor. It could be a tax lien like New York State, New York City, or whomever. All of these folks are named as defendants, and everybody's got to get served. The notice of pendency must be served within 30 days after being filed within the county clerk's office. And if it's not, then the lis pendens or the notice of pendency can be automatically stricken. Doesn't help that much because all the plaintiff would do is start over again on certain terms and conditions, but it can be stricken. And the summons and complaint must be served within 120 days after filing. That's statutory. And if it's not, the action can be dismissed. But again, it's somewhat of a Pyrrhic victory because on the one hand, the action gets dismissed, but on the other hand, the lender is free to start again unless there's a statute of limitations issue, or statute of limitations meaning the period for bringing the lawsuit has expired and they can't do it again, and that's usually not the case. So, after that's filed and the papers are served, that is, a process server takes the papers, finds the defendants, delivers the papers by one of the permissible means, the most common being handing it to the defendant. So if a process server comes to your door, bangs on the door at 8 o'clock in the evening and interrupts you and says, "Hi, I'm here, I've got papers for you," you are then officially served. Beyond that, if you serve an answer, appear, and there is a difference between the two terms, or if you just simply let the court know that you exist, the court will then schedule a settlement conference. And every court these days, Supreme Court is what we're referring to, every Supreme Court, and there's one in each county, has a foreclosure conference part. And that part is specifically dedicated to trying to work out a resolution between a borrower and the lender to see whether the borrower can keep the house. In the foreclosure conference part, what is done is that a mediator will take a look at the case and perhaps keep the case in there for several months, and during that period of time do their best to try and see whether a loan modification agreement can be worked out so that the borrower can keep their house. If it can't be worked out, then the case will be transferred out of the foreclosure conference part back into the regular session. One of the advantages of being in the foreclosure conference part is that there is an automatic stay or a freezing of all motion practice, any applications to the court that would automatically be made by a plaintiff in a foreclosure to push the case forward. And we'll talk about the steps that a lender will take in a few moments. Now, if an agreement is worked out in the foreclosure conference part, then the case doesn't go any further. A loan modification agreement is worked out, the case gets dismissed, and that's the end of it, and everybody proceeds on their merry way. However, if it does not get worked out, which is often the case, then, or if a borrower doesn't appear or has no interest in retaining the property and working out a modification agreement, then the case is transferred to the regular session of the court. The plaintiffs, or the party bringing the lawsuit, the lender, or as they call the investor, their next step would be to make application for an order of reference and summary judgment. Order of reference. What is an order of reference? It's an order from the court or a direction from the court stating that a referee has been assigned to the case, generally an attorney who knows the judge, has some contact with the court, as what's called a quasi-judicial officer. The referee is appointed to do various things in the case in terms of collecting and processing information as to payments or balances that are due. Now, the summary judgment part of that order would say that there are no issues of liability. Liability would rest with the borrower. It has been determined that the court has jurisdiction over the case and the borrower is responsible under the mortgage loan, and all that remains is to tidy up the case by determining what amount is due. Now, if an order of reference is issued, and it generally takes several months, if not well in excess of a year, to obtain an order of reference after the initial papers are served. After the order of reference is issued, then the referee will technically have responsibility to hold a hearing, to take evidence from anybody who desires to appear, and with that evidence to determine what balance is due under the mortgage loan. In practice, do the referees hold hearings? The answer, sadly, the answer is they do not. What happens is that the plaintiff's counsel will prepare an order from the referee, simply stating what amount is due in a referee's report, and it's all drafted by the plaintiff's counsel, so it's sort of one-sided in the plaintiff's favor, whether it's right, wrong, indifferent. And then the plaintiff would then bring another motion or an application to the court to confirm the referee's report and to obtain a final judgment of foreclosure and sale. Now, these motions do take some time. It has been the practice of the courts to sit on these motions for several months, sometimes in excess of a year. And that's done to give the borrower all the time and all the benefit of the doubt. But when that judgment of foreclosure and sale is issued by the court, then it's time for the plaintiff's counsel to refer the matter to the referee for the referee to post a notice of sale. Now, a notice of sale would indicate that the property is being sold at a certain time and date. It must be advertised under the terms of the foreclosure judgment. It's got to be advertised for 6 consecutive weeks. The sales are normally held at the courthouse steps or in the courthouse, although that does not have to be the case in Nassau County. It's in the county clerk's office. It can be elsewhere. It all depends upon the county. And then on the sale date, the property gets sold by the referee to satisfy the balance being due under the mortgage. That is the evolution of the case. Now, what I'm not taking account of right now are motions, defenses, things that could sidetrack a case, and there are numerous frolics and detours that a case can take depending upon the defenses that are being raised. There could be issues of discovery, in other words, an application by the borrower to take depositions, to extract information from the bank. There could be transfers of the loan from bank to bank to bank, or between loan servicers, which is an agent for a bank or an investor. And we'll talk about that in a different part. But anyway, these are the stages. This is the evolution, and I'll see you in the next part.